We going without Mr. Harmon?
That's fine, Judge, is my witness.
All right, very good. Welcome back. Everyone have a seat, and you may continue this cross-examination.
Good afternoon, Doctor.
Good afternoon.
Now, the state just received a copy of your report last night at 5:30 after the verdict, correct?
Correct.
That was the first time we saw your report.
Correct.
And then we conducted your deposition last night until after 8 o'clock?
That's correct.
Okay. Did you diagnose Granville Ritchie with anything? Did you give him an Axis 1 diagnosis at all
No.
after your 32 hours of interviewing him and meeting with him and testing him?
No.
No. Okay. And you met with him on 8 separate occasions, is that correct?
Correct.
For a total of 32 hours?
Correct.
And you spoke with his mother?
Correct.
You met with her in person as well?
Yes.
You spoke with an Antoinette Donaldson. Did you meet with her in person as well?
Correct.
And where is it that you met with her?
I met with her at the La Quinta Hotel down the road from the Falkenberg jail.
And she was described to you as a family friend?
Correct.
And you also spoke with or interviewed a Calissa Kelly?
Correct.
And did you interview her in person as well?
Yes, I did.
And she, in fact, told you she was Granville Ritchie's girlfriend?
Yes.
She didn't say she was just a friend?
No, that's correct.
She held herself to be his girlfriend?
Correct.
Okay. Looking at the family history that you obtained from, or that you have documented in your report, that is information that was self-reported by the defendant, correct?
Correct.
And how long is it that the defendant has been living here in the States?
Came at age 26, and now he is 40. So that's the last 14 years.
And in your report, you had documented that he had come here when he was 16 years old. Was that a typo?
That's correct.
I'd like to talk to you about his educational background. Did you have any records to review prior to the 9th grade?
No.
So anything that you would have learned or that you relied upon came straight from the defendant's mouth?
I mean, other than the records that I received?
Anything prior to
correct.
the 9th grade
Correct.
came straight from the defendant?
Correct.
Okay. You had no records to corroborate that?
That's correct.
And you stated that you had some records from 9th and 10th grade?
Correct.
Are you aware of what is required to be able to get into that Kingston Collegiate School?
That's what I was told. Yes, I'm aware.
You're aware of what's required to get into that school?
I'm not exactly sure what the exact criteria is, but I was told.
You were told what?
In other words, he had to be performing at a fairly decent level to get in.
To get into that school, right?
That's correct.
Okay. You don't just get accepted there because you're good in sports?
I'm not sure. I'm not aware of what the criteria is.
Okay.
I do not know.
So you just testified that you are aware that you have to test into that school?
That's what I understood, but I do not know what the exact criteria is or how you can get into the school.
Okay. So this is information you're relying on to come to your opinion, though?
That's correct.
You know some information, but you don't know everything?
That's correct.
Okay. The defendant reported to you that he had problems concentrating in school, correct?
Correct.
And did that go into your opinion with regards to him suffering from ADD or ADHD?
Correct.
There's no records to support that, correct?
In terms of difficulty concentrating in school?
Right, school records showing that he had problems concentrating in school.
No, they're only test scores.
So that would be a no. You don't have any records to corroborate that.
That's correct.
Do you believe he still suffers from ADD and ADHD today?
Yes.
Is he on medication for that?
No.
Are you aware of any outbursts that have occurred over the 3 weeks that we've been sitting in court for hours on end?
No.
Moving on to the employment history, what records did you have to corroborate the defendant's employment history?
The only records that were available were from Versaire, the catering business that he was involved with while he was in Jamaica.
So you didn't have any records from any cell tower company?
That's correct.
Not one in Jamaica that he worked for?
Correct.
Not one here in the United States?
That's correct.
So everything that you noted in your report or you relied upon came from the defendant with regards to the cell phone tower employment?
That's correct.
And you reviewed some records for Versaire?
Correct.
And that was when he was living in Jamaica?
Correct.
He was a food loader onto the airplanes?
Correct.
Did you thoroughly review those records?
Yes, I did.
Were you aware that a Caribbean secondary education certificate is required to maintain and hold that position?
I'm not aware.
Were you aware that it's required for 5 subjects to be including math and English to be able to hold that position?
I'm not aware.
And you would agree that a secondary education certificate is something like a formal GED or an AA?
What's AA?
An associate, I'm sorry.
No, well, associate's ready college degree. No. No.
So you don't think secondary education certificate, including 5 courses for mathematics and English, to hold a food loader position, that wouldn't be equivalent to GED or close to an AA?
An AA is beyond the GED, but no, I'm not aware.
Okay. You would agree that that would be inconsistent with your cognitive impairment
That's
opinion?
correct.
You mentioned that he, the defendant, had been involved in some accidents. You had very few, if any, medical records to document these accidents, correct?
Correct.
Okay. So, again, you're relying on the self-reporting of the defendant?
Correct.
And so there was a slip when he was 10 years old and he hit the back of his head?
Correct.
You aren't aware of him requiring any stitches from that?
Correct.
No broken bones?
Correct.
No concussion?
Correct.
No loss of consciousness?
That's correct.
No hospital records to document that?
That's correct.
That's completely and solely his self-report?
That's correct.
You're not even aware of what kind of surface it was that he slipped and fell on?
That's correct.
Okay. Then there was another incident when he was a child, but there was no head injury in that incident, correct?
I'm not sure what you're referring to.
The desk incident?
Yeah, it's unclear.
Well, didn't you testify last night in your deposition that it wasn't in fact his head that got injured, it fell on his shoulder?
That's correct.
Okay, so it had nothing to do with his head.
Well, a huge desk coming from above, when it falls down, in all likelihood, between the shoulder and the head, it's going to be including in the head as well, part of it.
But you don't have the facts as to how this happened, correct?
A
You're
desk,
assuming.
well, I was told.
Okay. You were told a desk came out of what?
A desk fell from above down on his, onto him.
Did it come out of a window?
No,
Did it come off of an elevated balcony?
no, I'm not sure.
You don't know,
That's correct.
right? Okay. You don't even know what kind of desk it was.
That's correct.
Okay. Again, there was no report of needing any stitches.
Well, he was taken to the Bustamante Hospital, but I was unable to obtain those records.
Okay, so you were told by the defendant that he went to the hospital regarding that injury,
That's correct.
but you haven't reviewed any records to corroborate that.
That's correct.
All right. Did he tell you he needed stitches because of that incident?
No.
Did he
was-
report any loss of consciousness?
No, he was 10 years old.
Okay. But I would assume that an incident like this, if a desk is falling on you, that's an incident you're going to remember.
Well, it certainly was traumatic, and yet he remembers.
But he didn't report any injuries.
No, he reported there were shoulder injuries.
Shoulder,
That's correct.
not head injuries, correct?
That's correct. That's what he remembers.
And you summarized that he was involved in a couple car accidents. Is that correct?
That's correct.
You haven't been able to review or ascertain any actual police reports with regards to these car accidents.
That's correct.
No insurance claims regarding the car accidents.
That's correct.
You haven't reviewed any medical records with regards to these car accidents.
That's correct.
Nothing to confirm any injury.
Well, no, there is one accident is reported, and so there's records of the fact that the accident did occur.
So for one of the accidents?
That's correct.
Okay. But you have no information as to if he was injured.
That's correct. Well, there's in the report itself. It's some vague terminology that's hard to understand, but it seems that he was unrestrained and he was taken off in a stretcher. That's what it appears from this record.
Can you show me where in the record it says he was taken off in a stretcher?
It says here, any visible signs of injuries from the crash and person had to be carried from the scene.
So somebody had to get him from the scene, but it doesn't say anything about an ambulance arriving or being carried off in a stretcher, correct?
I'm sorry, it just said it was carried from the scene.
Okay. And it's not even clear where this record is obtained from. Is that fair to say? What database where this record came from? Nothing.
That's correct.
Okay. So we have no records telling us he had a concussion,
Correct.
loss of consciousness,
Correct.
or if he even had any head injury.
Correct.
All right. You discussed there was another car accident in 2011.
Correct.
We have no records to hospital records documenting what, if any, injuries he had.
Correct.
That's all self-report from the defendant with regards to this 2011 accident.
Correct.
He didn't report to you he lost consciousness.
Correct.
He didn't report he had a concussion.
Correct.
He didn't report he had any broken bones.
Correct.
He didn't report that he required any stitches.
That's correct.
Now, you did have a medical record that you reviewed from May of 2012, correct?
Correct.
And that medical record was a hospitalization for exhaustion and dehydration,
Correct.
not a head injury. Correct?
Well, there was suspect that there was a bleed in the brain.
Are you aware that CT scans are typically done when they're working up someone for dehydration and exhaustion? Are you aware of that?
Well, that's true, but there's also questions in terms of dizziness and also because of possible you're going to have a bleed to the brain if there's trauma. It's not because it's internal, it's because it's some external source.
Well, he didn't go to the hospital in May of 2012 for trauma. He went for exhaustion and dehydration.
That's correct.
Okay. So I want to make it clear to the jury that there was no brain trauma in May of 2012 when he went to Brandon Hospital.
We don't know. As I said, they did perform the CT scan and says rule out bleed to the brain.
So a CT scan was normal on May of 2012.
I understand, but again, that's what the suspect was. That's correct.
But the CT scan was normal.
That's correct.
Not abnormal. It was normal.
That's correct.
Okay. And you had 2 pages of an entire medical record.
Correct.
From his admission. 2 pages. Not the entire time he was there.
Correct.
And he was there for several days. A couple days.
Correct.
Okay. Then he had an MRI in June of 2019, and that was normal.
Correct.
You discussed previously that the defendant had witnessed several friends being murdered in front of him and violence, and that possibly suffering from PTSD. Have you reviewed anywhere in all of the records that you said you did review anything or anybody diagnosing him with any kind of mental illness?
No.
So he's never been diagnosed with PTSD,
Correct.
not diagnosed with depression,
Correct.
no mental illness.
Well, I mean, at the present time, he's on an antidepressant. He's on an antipsychotic. He's also taking Visceral. So there are 3 medications at the present time that he's taking.
Well, is there an Axis 1 diagnosis that he's being prescribed those for a particular reason?
I don't know. I haven't seen an Axis 1 diagnosis, but the fact that he's receiving 3 different medications, an antipsychotic, an antidepressant, and Visceral to help with anxiety and sleep and restlessness would indicate that there's some serious mental illness. Medications aren't prescribed if there aren't major issues.
Well, typically, if someone is getting those drugs for a mental illness, it will be somewhere in the record. You would agree with me,
That's true.
correct?
I did not see it.
And is it unusual for people who are incarcerated, such as the defendant, to suffer some depression and anxiety,
That's
being
true.
within their living quarters?
That's correct.
That is common, correct?
That's correct.
Okay. You talked about validity tests that you conducted to determine whether or not he was malingering or faking, correct? When you were going to be administering these tests?
Yes.
And when you do a malingering test, are you doing that test as you are then conducting another test, or do you do your malingering test and then move on to your next test?
The malingering tests were conducted at several different times. It doesn't necessarily have to be at the same time, but at different times of the evaluation, it was conducted.
But so someone could do well on a particular malingering test, and then the next test be faking. That could happen, correct?
It's possible, but unlikely.
And you didn't do a malingering test or a validity test every single time you met with him?
No.
Counsel, can you approach real quick on something? Mr. Harmon, hold up.
Before I move on, Doctor, I want to ask, there's been no previous diagnosis of ADD or ADHD.
That's correct.
And the CT scan that we discussed from Brandon Regional Hospital from May of 2012, that was of his brain.
That's correct.
Okay. And the antipsychotic that you said that the defendant is taking, what is that antipsychotic?
He's taking Abilify.
And you have no idea why he's taking that, correct?
No. But antipsychotics are not given without some significant issues, psychiatric issues.
But you have no idea why, and you reviewed the records.
Well, I did not review the records in totality to explain why he was given the medication. I did not review those records.
You didn't think that was important? You didn't think that was important to review prior to your testimony here today?
Of course it's important, but you don't have access to everything.
Okay.
Did not have access to those records.
Well, you had access to his jail records, correct?
Correct.
And your testimony here today is that the defendant suffers from a cognitive impairment, but he does not have an intellectual disability.
That's correct.
Okay.
Well, intellectual disability meaning he's not in the below 70, which would be intellectually impaired. That's what that means. But yes.
Well, not only
Excuse me. Wait, let me finish. Excuse me. His IQ is still in the borderline range, but doesn't meet the criteria for intellectual disability, just to clarify.
Because you have to have more than just a low IQ to be intellectually disabled, correct?
That's correct.
Okay. Now, looking at your report, I do see a number of tests that you did perform on him. I did not see one area at all with regards to the facts of this case. There's nothing in this report referencing any fact
That's correct.
of this case, correct?
That's correct.
Did you review the police report in this case?
Yes, I did.
Did you review the defendant's recorded statement in this case?
No.
Did you review any of the interviews of the multiple women that he was dating in this case?
No.
Are you aware of the manipulation and planning and actions of the defendant in the facts of this case?
With regard to what?
Well, manipulating Miss Wiley so that he could be alone with the victim in this case? Number one?
Yeah, I did not review that.
Okay. Making sure Ebony Wiley couldn't get in the gate by giving her a wrong gate code so he would have more time to hide the body. Were you aware of that?
No.
Juggling all of these women at one time in these various relationships. Were you aware of that?
No.
Purposely disposing of the body in water to prevent possible DNA from being located. Were you aware of that?
No.
Manipulating Miss Wiley and getting her to tell a lie so he had time to cover up what he did. Were you aware of that?
No.
You would agree that all those things of manipulation are wholly inconsistent with someone who's being cognitively impaired.
I'm sorry?
The manipulation that I just discussed is wholly inconsistent with someone who's being cognitively impaired.
Is what?
Inconsistent.
What did you say? Holy?
Completely inconsistent with
holy,
someone
okay.
being cognitively impaired.
No.
You don't think that that's inconsistent?
No.
Do you think it's consistent with somebody who has an IQ of 78, being able to juggle all that?
It's not, no, that's not inconsistent.
It's not inconsistent. Did you consider all those facts when you were reviewing your test scores with regards to his executive function?
No.
Did you consider any of the facts of the case when you came to your ultimate opinion in this case?
No.
You relied upon statements from the defendant and your test scores, right?
That's correct.
Okay. You gave the test of one of these 25 tests, you gave him a motor functioning test to test grip strength?
Yes.
What was the purpose of that test?
The purpose of giving motor measures is to see the comparison between right and left hand in terms of the right hand controls the left side of the brain and vice versa. So you're looking to see in terms of different motor measures, in terms of their performance and how the brain functioning of the opposite side corresponding to that hand is performing.
Do you think that that would be a test that would be easily faked?
You could.
Okay.
And he scored in the average range on 2 of the 3, and only 1 of the 6 measures was he impaired. So 5 out of the 6 he was average, normal, and 1 with his dominant right hand on the Lafayette pegboard, he was mildly impaired, which is consistent with left brain impairment.
Is that consistent with your diagnosis?
Yes.
Okay.
Well, I didn't diagnose him, but I, again...
That's right, excuse me, you didn't diagnose him. With your opinion.
That's correct.
Okay. Looking at the Minnesota multifaceted personality inventory test that you administered, doesn't that test give you a report that's approximately 20 pages?
It's not that long, but yes, there's a report.
How long is it?
I think it's about maybe 10, 12 pages.
And you've condensed that to 6 lines in your report.
That's
correct?
That's correct.
There is a validity scale contained within that test. Is that correct?
Correct.
Can you tell me what his faking scale score was?
It's 12 pages. His F score was 85.
What does that tell you?
It's a little high, but the could be that somewhat exaggerated responses, but still it's considered a valid. The MMPI is still valid.
But it's a little high for faking.
That's correct.
Okay.
Exaggerated.
So in other words, he's exaggerating his possible cognitive impairment.
No, this is not cognitive impairment. This is psychiatric symptomatology.
I apologize. The personality.
That's correct. Well, part of the test was considered to be more exaggerated. Other part was considered to be fine. So that's how the test came out. But it was valid and scoreable. So those were the test results.
Did you evaluate him for antisocial personality disorder?
Yes,
And you didn't find him to have that?
that's correct.
Let's talk a minute about this risk of recidivism test. This VRAG test. You can't predict the future, correct, doctor?
No one can.
You have no crystal ball.
No one does.
Okay. Would you agree that a good predictor for the future is looking at someone's past behavior?
That's correct.
You stated on direct examination when you were talking about his frontal lobe impairment, and that could have been due to several head injuries or traumas. What specifically do you have? What documentation do you have to support your opinion that there were, in fact, injuries?
Well, there was a car accident that was documented. There was several report of early on incidents, which was also corroborated by his mother. So there was questions about doing a brain scan. So in other words, there was multiple different events that occurred. Whether or not there was a loss of consciousness, but there was suspect of different events that had traumatic events that involved the head.
So you said that the incidents when he was a young child were corroborated by his mother, Gloria Gibson?
That's correct.
Not an actual document?
That's correct.
Were you aware that Ms. Gibson lied to law enforcement in this investigation?
I'm not aware.
Okay. And then you said the other thing you relied upon was this accident report, which we don't know where it came from.
That's correct.
And it just says he had to be carried from scene. That's all we know about it.
That's correct.
So that's what you're relying on when you say he sustained injuries.
That's correct.
Okay. The only medical record that you have, in fact, put your hands on and reviewed is the 2-page report from Brandon Hospital for the exhaustion and dehydration admission.
That's correct.
You talked about the defendant's father having 18 children by multiple women.
Correct.
Were you aware the defendant had multiple women in his life?
Yes.
And the defendant was cooperative when you met with him on multiple occasions, correct?
Yes.
You are a psychologist with a PhD,
Correct.
not an MD or a radiologist.
That's correct.
You commented also when you were talking about risk of recidivism that the defendant had no DRs. Were you aware of a diagnosis within his medical record stating cannabis use disorder in partial remission? Were you aware of that?
Yes.
Would you agree that typically when it says in partial remission, it means that while he was incarcerated, there has been some association with marijuana?
I'm not aware.
You're not aware of giving that diagnosis partial remission means that he somehow has gotten in trouble for marijuana in the jail?
Yeah, I'm not aware.
Because usually if they're incarcerated and they haven't had any marijuana, it will say in remission in a controlled environment. Right?
Yeah, I'm not aware.
You're not aware that that is what typically the diagnosis is, or you're not aware of any DRs?
I'm not aware of what the DR I think there was one initially. I don't think that, I'm not sure what it was, and I'm not sure what it means when they say impartial versus controlled environment. I didn't have access to the records. I don't know.
So when you just testified a minute ago on direct examination that he had no DRs, that was in fact not true, because you are aware of a DR.
I'm sorry. There was one DR. Other than that, that's right. There was no DRs. That's correct.
Okay. So he has a DR.
Yeah. That's true.
Okay. When you said that no one willingly fails out of school, someone can fail out of school for lack of effort, correct?
That's true.
Okay. Were you aware of anywhere in his employment records that in fact it's documented that he has some issues with effort and giving full effort?
I'm not sure.
You're not sure. So you did not see anything in his employment records regarding his effort in his employment? The food loader.
Well, no, he was. I mean, I think it was. It wasn't 100%, but it was given. Passing. It was given different percentages. But he never. It was fine. I mean, it wasn't an issue in terms of not being compliant or not being dismissed from the employment. No.
But he had reviews where there was discussion about his effort. Correct?
This is what it stated. Job performance was 68 to 72%. He resigned from the work. He was a hard worker, cooperative, willing to assist, dependable, maintains good customer relations, willing to extra mile, willing to be a team player, very flexible.
And in fact, he made a very nice resignation letter that he gave to his boss.
Correct.
Very thorough, very appreciative, typed out.
Yes.
That being inconsistent with someone who is scoring 78 on the IQ score and who you are saying is cognitively impaired.
Yeah, I'm not exactly sure who wrote the letter, if he had assistance, but no, I mean, I did not say that cognitive impairment at 78 you can still type a letter, even if he would do it by himself.
You testified that he sent money back to Jamaica, giving it to family and friends. Where was that documented? What record did you review for that?
That was self-report.
Okay. Doctor, how much do you charge per hour?
$200 an hour.
And how many total hours have you worked on this case?
Well, 32 plus more hours of report writing and review of the records. So
how many hours would you say that is?
I have to look, but it was more, obviously.
More than 50?
Yeah. I didn't tabulate the hours.
Nothing further, Judge.
Okay, redirect.
Thank you. Doctor, you are aware of one DR, correct?
Correct.
In 5 years of incarcerated or plus 5 years?
Correct.
Okay. Now, you were questioned about the defendant's learning abilities, correct?
Yes.
And you've indicated that there were limited records, correct?
Correct.
Was your testing of Mr. Ritchie consistent with the information that you were being provided with?
Yes.
Okay. And you said you had talked to other people, correct?
Correct.
Did they provide you any information about his childhood or his learning abilities?
Yes.
Okay. Were they consistent with your testing and what Mr. Ritchie reported to you?
Yes.
You also, of course, have testified about the head injuries, correct?
Correct.
And despite the fact that some of it was self-reporting, was it consistent with the testing that you were conducting?
Yes,
And was it consistent with information that was being provided to you by the other people that you talked to?
yes,
Okay. And you were questioned about the medication that Mr. Ritchie has been being given at the jail, correct?
correct,
I think one of the things was antipsychotic medication?
correct, Abilify.
And two other things?
Yes, he's also Zoloft, which is an antidepressant, and Vistaril for anti-anxiety.
And although you have not seen the actual diagnosis, is that type of medication provided just at will, or is it based on some kind of medical analysis?
Right, it was the psychiatric analysis that was done at the jail that he is in need of that medication.
And are you aware that specifically, even more importantly, the fact that Mr. Ritchie is from Jamaica, that it was difficult obtaining records from Jamaica?
That's correct.
And you've been in contact with the mitigation specialist in this case, Ms. Colleen Quinn, who's not in the courtroom right now, but has been in the courtroom, correct?
Correct.
And where you provided information that certain records could not be obtained?
That's correct.
Okay. And was it your information that some of it had been destroyed because of where it's at?
That's correct.
The state suggested to you certain acts of what they referred to as manipulation, correct?
Correct.
And asked you, is that inconsistent with an IQ of 78? And I believe your answer was that it is not inconsistent, correct?
Correct.
Explain to the jury, what does that mean? The fact that there's an IQ of 78 and these suggested acts of manipulation, as the state refers to.
Mr. Ritchie certainly is street smart, meaning he knows how to navigate the world. He was employed all these years, so he drives a car. He made financial statements. So somebody with an IQ of 78, it's not inconsistent that he's able to do all those things. He had relationships with multiple women. He was able to form a relationship. He was married for 8 years. He raised 2 stepchildren. All that is the fact that he has certain skills that he's able to maintain the best of his ability with other people and with employers. Never found that he was fired from a job. He left on his own will. But again, somebody with an IQ of 78 still is street smart enough that he's able to function, notwithstanding the fact that he still has brain impairment that I detailed earlier on.
And even though, would it be correct to say that even though you determined there was brain damage, you felt that there was a need for further testing, which is the PET scan and the MRI, correct?
Objection, leading judge? Overruled, go ahead.
That's correct.
Thank you, that's all I have.
Okay, may this witness be excused?
Yes, sir.
Okay, very good. State and defense approach real quick. Okay, jury's up to court, everyone have a seat. Okay, so what's the issue, Mr. Harmon?
Judge, I object to this testimony from this witness. I was under the understanding he was going to be testifying to some testimony concerning whether the defendant would make a good inmate or not. Now, what I was just told by the witness is he's going to testify to conditions in open population, conditions on death row, and now counsel's saying he's going to testify that the defendant, in his opinion, would make a good inmate. I don't understand how a non-medical witness, a lay witness who worked in the Department of Corrections, can give an opinion as to whether some individual in the future predicting his behavior is going to make a good inmate.
Go ahead.
That goes to the merits, not the admissibility. I intend to ask him about prison life, how it, general population compares to death row. That's part of what I was going to ask him. But he has interviewed, he has visited Mr. Ritchie at the jail, and based on his interview, and based on all these years of working in a jail as a corrections officer and in law enforcement in general, that he believes that Mr. Ritchie would not be a cause of of trouble at the jail. That's basically what his intent, my intent is to get into.
So propensity evidence is based on his past behavior?
Correct. That
How is that admissible? I don't see the reliability of that evidence. I don't see how it's admissible. And also, what difference does it make what the conditions are on death row? How is that admissible in a penalty phase hearing?
Judge,
Why is the jury entitled to hear what the conditions are on death row versus open population?
I think it's very relevant, and I can tell you that he and other people of his experience have testified in death penalty cases in the past.
The
I
case law says
understand, but with regards to why, the whole issue the jury's trying to determine is if life without the possibility of parole would be the appropriate sentence in the case, correct?
Correct.
And so then the issue would be, okay, if you're not on death row, you're not being housed as a death row inmate, you're going to be put in a general population. How would you do in a general population? So I don't see then what the relevance would be, how someone would do on death row, because if you're on death row, you're ultimately going to be executed.
No, I'm sorry, I stated that. That's not what I meant to state. He would testify as to how he would do in general population.
Okay, that's
but
fine.
he would also testify about for the jury to get information of the difference between living on death row versus living in general
Well,
population.
what's that relevant to? What is living on death row relevant to? Because then the whole point that you're trying to make to the jury, I assume, is that, listen, this defendant's not going to be, there's not going to be any further trouble. If you send him in a general population, he spends his life there, he's going to be able to acclimate, he's not going to be killing other inmates, he's not going to be sexually abusing other inmates, he's not going to be doing anything. The conditions on death row, candidly, are irrelevant, because then at that point, if the sentence is one of death, death row is just a holding place until ultimately a defendant is executed. So what's the relevance of how he would do on death row?
Judge, he would, I think, I'm not saying that he would testify about how he would do specifically on death row, because I agree it's a holding area. However, he would testify as to the fact that in some ways life on death row is better, because you have a television, you have some solitude, but you have actually certain privileges that you don't have in general population. And I think that the jury should be educated as to when they're voting for one or the other, they should be able to get a better picture of what they're voting for. And part of that vote would be, well, I don't want to send him to death row if he's going to have all these privileges. That's part of what his testimony would be.
I know, but they're just temporary privileges until someone's executed. So I don't find that there's any relevance to what conditions would be on death row. Because if the jury makes an ultimate determination the defendant's going to be executed, then that's their decision. Now, you can elicit from him why this defendant would be amenable to general population prison, and why, and what the conditions would be, and how he would be able to act on it.
Judge, I would argue the court, and I agree with the court on the death penalty issue of death row, but Dr. Eisenstein just testified based on I think it's called the Bragg test that he conducted, that the defendant has a low likelihood of future recidivism and dangerousness. So that evidence is before the jury.
I know, but listen, that's closing argument, okay? I'm not going to limit when it comes to sentencing phase. I'm not going to limit the amount of information that the defense wishes to put forward regarding this defendant's amenability to a sentence of life in prison without the possibility of parole.
What I was going to suggest was that the witness be limited to testifying to the conditions in open population if he was sentenced to life, what those conditions are, what would be required of the defendant, what he as an inmate would be required to do during the day, what availability he would have to other inmates, not a layperson's opinion about his propensity to commit violence in the future. That can come in through Dr. and it did, through Dr. Eisenstein.
All right, I will allow the witness, and we'll just see how things go. He can't start opining into medical diagnosis, but based upon his training experience, I will allow him to testify that based upon what he's seen in the records and speaking with the defendant, he believes that the defendant would be amenable to life in prison and would be able to be a successful inmate.
And Judge, may I step up for a moment to let him know what I'm not going to be able to ask?
Yeah, we're not going to get into conditions on death row. Okay, we ready to proceed? Okay. All right. Let's bring our jury back in. Okay, very good. Welcome back. We're ready to proceed. And Vince, call your next witness.
Aubrey Land.
Do you solemnly swear or affirm that the testimony you are about to give in this class is the truth, the whole truth, and nothing but the truth, so help you God?
This way, sir.
You may proceed.
Thank you, Your Honor. Sir, could you state your name and your occupation?
My name is Aubrey Perry Land Sr., and I'm a prison and jail law enforcement consultant.
Can you tell the jury a little bit about your occupational history regarding law enforcement and corrections?
Well, I started my career in 1984 at Mayo Correctional Institution as a correctional officer. I promoted up to the rank of sergeant, left from the department in '89, served with the Lafayette County Sheriff's Office in a reserve capacity and then into a full-time position. Went back to work with the Department of Corrections for a short time in, I think, 94, left again in 2000, or 96. Was hired by the Lobe Police Department and was promoted to a detective quickly after assuming that position. Stayed there until 2006. I was hired by the Florida Department of Corrections Office of the Inspector General as a law enforcement inspector.
Do you have any occupational training?
Yes, sir. I had a certificate in law enforcement and a certificate in corrections.
Okay. And do you have any other specialized or advanced specialized training?
I have taken many training courses throughout my 33-year career. Homicide investigations, drug investigations, models for management, use of force, chemical agents, taser certifications, speed measurement, interview and interrogation skills, multiple classes on that, yearly training, which consisted of high liability areas. The list goes on and on. We could be here for a good little bit.
Do you presently have a firm that deals with professional law enforcement and corrections?
I do, and my firm is called, or I say firm, it's my private business. It's Fair Play Justice.
Okay. And does part of that business deal with law enforcement, prison, and jail consulting?
It does.
And have you, and tell the jury, if you would, please, what does that encompass?
I work for whoever hires me. I work quite a few in-custody deaths. I've worked suicides, homicides, aggravated battery cases to where there has been civil litigation related to it. Use of force issues, one failure to protect, inmate transports. Been doing quite a few resentencing cases under Miller-Graham. And the Miller-Graham cases are juveniles who were sentenced to life in prison and have since been, the courts have since determined that they are to be resentenced. I go in, I look at their classification history, I look at their adjustment within the Department of Corrections, how well that they have adjusted, or in many cases, how they have not adjusted and complied with the rules and regulations. And then I'm called upon to to testify to the court about their time in the Department of Corrections.
Would it be inaccurate to say that you have qualified as a prison expert? Would that be a correct terminology?
Yes, sir, on several occasions.
Okay. Can you estimate how many times?
Five or more.
Okay. Your Honor, at this time I would offer, I don't know if the state wishes to voir dire, I would offer Mr. Land's testimony as an expert in the capacity of a prison expert.
I would like some voir dire, Your Honor.
Okay.
Thank you. So what's a prison expert?
Understanding the operations of a correctional facility, what it takes to actually run that facility, how we classify inmates, what our security levels are within those, within the confines of our prisons and our.
You mean
and our
here in Florida, right?
Excuse me?
You mean here in Florida?
Yes, sir.
All
I've
right.
also testified in Alaska as an expert.
But that wouldn't be dealing with the Alaskan Department of Corrections, would it?
Yes, it would.
Your familiarity with them was based on what? You read some stuff about it, or you actually worked up there in the Alaskan DOC?
No, actually, it was a death case, or actually a inmate death case. And I was hired by the plaintiffs in the case, and I provided testimony on how security procedures were not followed in that particular incident.
All right, and that would be commonly accepted security procedures amongst Department of Correction facilities in the United States and different states?
Most all of your security procedures are similar. I mean, there's going to be wording difference, there's going to be a
Right.
few things omitted, some things added to different policies and procedures around the country. The industry standard, the American Corrections Association, the American Jail Association, those are two organizations that kind of help set the standards that we should apply. They do a lot of the accreditation. There's other accreditation companies out there that help accreditate jails, correctional facilities. The industry standard as far as the care, custody, control, supervision, accountability, safety of inmates, our security procedures, our medical procedures that we're required to provide for the inmates, the way that we transport inmates, and other things of that nature. There's a pretty well standard way of doing that.
Right. Standard way of doing that pretty much consistently throughout the United States?
It's pretty consistent in, like, the long-term transportation of inmates, for example. You have prison transport companies that transport inmates all over this country, and that is all covered under the federal rules of interstate transport.
Okay, so there's standard procedures, there's standards that the certifying agencies recommend, at least for their certification.
There are a lot of, well, if you're accredited, yes, you've got to follow it. Excuse me. You have certain standards. You have policies and procedures that most accreditation companies require you to update your policies and procedures on a regular basis. And I'll give you one example, if you would like that, of why. We see throughout the country a lot of inmates who are coming into local jails and so on of that nature who are chemically dependent upon opiates. And without the proper treatment, we're seeing a lot of them get sick. We've seen some of them die from opiate withdrawals, alcohol withdrawals as well. So as time has evolved, we have to change those procedures to accommodate what we're actually seeing in corrections across the country. So that's kind of the reason that there is an industry standard.
Right. So there are industry standards, right?
Sir?
There's industry standards when it comes to incarceration in the different Department of Corrections around the United States?
Most everybody adopts the standard approach of the care, custody, control, supervision, accountability of inmates. One jail may do things a little bit different. They may have cameras in one place and not in another. They may have things can vary, but as far as our security, what our goals are, what we're supposed to do, how we're supposed to house the inmates that are entrusted in our care, the quality of care that we give to them and that we give to the civilians that, or the citizens that entrust us with that care is across the country pretty similar.
So care, custody, control, and the quality of care. Supervision.
Accountability.
Accountability of the department itself.
The accountability of the inmates in our care.
Your accountability for them or their accountability for themselves?
We are accountable for maintaining them in our system, and that is through our custody and control. The care of the inmates, we have a standard of care that if they require medical attention, that we give it to them. If for example, if you have an inmate who is suicidal, there are certain things that we have to do to protect that inmate. One being place them on suicide watch. How we do that is pretty much so an industry standard that we place them in a room where we watch them. We remove articles from them. They're normally disrobed. We give them basically a little blanket that you put around yourself. Suicide shroud is what we call them. And then we have someone who is monitoring that person to make sure that they're not committing acts of self-harm.
Thank you. I have no other questions.
Okay, counsel approach real quick.
Sir, were you asked to take a role or take part in this case, State of Florida versus Granville Ritchie?
Yes, sir.
And what did your role, what did you perceive your role to be?
My role is to, one, talk to Mr. Ritchie and to kind of feel him out, understand let me kind of back up and explain this. Correctional staff's job, when we have an inmate that comes in with a very lengthy sentence, we should give them some type of a roadmap to follow, because there's really no directions of how to do this. And so I kind of started that process and sitting down with him, explaining to him the differences of sentence that he may receive. And one of it, which being if he were to be sentenced to life in prison, that he would go into our system. They will do a classification of him. They will determine the needs of the agency as far as how high of a risk of an inmate that he would be. And due to the length of sentence, the type of crime, he will be classified HO5, which is maximum security. He would be housed in a housing unit where he would be only with one other inmate in the cell. Particular times of the day, he would have access to go and mingle with other inmates within his dormitory. Sometimes out in called recreation time, to where they would go onto the recreation yard and actually be able to walk or sit around and communicate with other inmates. He would have a canteen that he would have the opportunity to go to and buy sodas and different things of this nature, help them comfort items. Then he's required to be back in that dormitory at certain times, be controlled feeding to where he would be escorted up to the chow hall and would eat with probably 80 to 100 other inmates at the time. Controlled movement to medical. He would have rules of conduct that he would have to comply with. There are medical protocols for how he is to obtain medical assistance. If it's an emergency, an inmate can declare medical emergency, and they get seen by medical. Psychological emergencies, and many inmates do have psychological emergencies according to their psychological needs. When that happens, then we get them immediately to a mental health professional. So I kind of go over this with him to help him understand how the system runs. And then my next part is to explain to this court kind of what we just talked about just a moment ago of how he would be housed if he was sentenced to life in prison.
Okay. And if you could describe the difference between being housed in general population for a life sentence versus death row. Describe the differences, if any, between the two.
There's obvious differences. Death row would be single cell housed. It would be he would have no other roommate with him. A lot of his, say if he had a medical call out, sinus infection or whatever, good possibility that the doctor would come cell front with him and actually see him there because of the manpower that it takes to move a death row inmate from death row over to, say, medical. Time consuming and different things of that nature. It might actually be quicker for the doctor or the other medical staff to come and actually see him. He's going to have, if he's on medical call out, they're probably going to come to his cell instead of being escorted to the medical unit.
Are there actually certain privileges given to someone housed in death row that someone in general population does not get in serving a life sentence?
The one thing or a few things that I could think of right offhand is on TV. He would have the access to control that TV, watch what he wanted to watch on TV when he wanted to watch it up until the time that it's cut off at night. In an open population, he shares that with anywhere from 50 to 80 other men, and then it's by majority rule as to what is watched on TV. Basically, and I mean, I'm not making light of it, we would refer to it in my profession as he gets room service. We're going to bring his meals to him. He doesn't have to go and get them.
And is life, going back to the general population, and there appears to be a lot of rules, correct? A lot of rules that have to be followed on a day-to-day basis, correct?
In open population?
Yes.
Well, I would say that there's a lot of rules that have to be followed, period, by inmates. There's a requirement of keeping your voice down to when you go to certain areas of the institution, when you can go to chapel, when you can go to eat, when you can go to the canteen. We have a lot of controlled movement. We have a lot of rules and regulations that inmates are required to follow.
And would it be accurate to say that there are some people given life or any kind of prison sentence that are not apt to always follow the rules?
Objection, leading.
I will. Go ahead, you can answer.
If you could repeat that one.
Are there prisoners that are not good at following rules?
There's a lot of prisoners that are not good at following rules.
Okay. Now, you said that one of the things that you did in this case was interview Mr. Ritchie and explain these rules, correct? And what life in prison is like.
Yes, sir, I did.
Did you form any opinion based on your interview of him regarding his adaptability to follow the rules and his adaptability to live in prison without causing trouble?
Well, I went a step further, but I did talk to him and have some idea and an opinion of whether or not he can conform to the rules. According to the jail staff, he has done pretty well to conform to the rules at the local jail. They've not had a problem with him. He is housed in a little bit of a different environment. It's not an open population environment at the local jail, so his mixing and mingling with other inmates has kind of been restricted. We don't have a real picture of him in open population to make a determination. And briefing him on some of the things to expect and some of the things of how he would want to try and conduct himself and how to protect himself if he were to be in an open population environment, I believe that he would conform okay.
I object to this. I would object. He's not qualified to give an opinion about what this defendant would do in the future. He's not a mind reader.
I understand. I'll overrule the objection. You go ahead and answer the question, just based upon your own personal training and experience. But again, ladies and gentlemen of the jury, as with the first phase of the trial, you can believe, disbelieve all or any part of any witness's testimony that you're called to make as the finder of fact. Okay? All right, go ahead.
Thank you.
So, you were in the process of answering the question, but to make sure it's all in context, do you have an opinion regarding his adaptability to serving a life sentence living in prison?
I believe he could adapt to an open population setting, that he would conform to the rules. He's fairly mild and meek, and when you're talking to him, the staff describe him as such. He is not a problem inmate. I don't believe that you would see a lot of outbursts from him. I think he's going to try and conform to the rules and regulations as best as he can. Every inmate is going to mess up at some point in time. There's going to be some type of intervention by correctional staff, and they start, if they see it, then they start trying to nip it in the bud. They start taking progressive discipline to try and prevent any further violations.
Thank you. That's all I have.
Okay, Cross?
So as far as him being a good, well-behaved inmate, not a problem inmate in the Hillsborough County Jail, he's been in lockdown pretty much the entire time he's been there, hasn't he?
That's my understanding.
All right. And as far as his ability to adapt in the future, and him being mild-mannered, and I think you said meek, is that right?
He's, in my impression, in my talking with him, he's kind of a meek individual. Mild-mannered, right? Yes, sir, mild-mannered.
How long did you spend with him when you met with him?
I only got about an hour and a half.
Okay.
And my assessment of him was after he told me that he had been up since early that morning, had been in court. This was the 24th. Met him about 6 o'clock in the afternoon, if my memory serves me correctly.
Okay. So you had an hour and a half with him, and that's the entire time you've ever met with this defendant or spent with him?
That's all the time that I've had with him.
Out of how old is he, 40 years?
Yes, sir.
Okay, you spent an hour and a half with him. That would be a very small, very minute fraction of his entire life, wouldn't it?
That is
That you
correct.
spent with him. You'd have to admit, you really don't know this man very well, do you?
I would not sit here and try and convince this court that I know him.
Right. And I think you heard me. My objection, you're not a mind reader, right?
I would never, ever offer to be one.
All right. And you can't put yourself into his shoes or into his mind to determine how he may act or not act in the future, right?
I can't. As a correctional professional, we have, I think the last count, 96,000 inmates in the Florida Department of Corrections. Our classification team tries to do a very good job of classifying inmates.
And when you say our, you're not a part of the DOC anymore, right? I just want to
I'm
clarify
bad
that.
to speak that I'm still,
I know, and I'm not faulting
And-
you. Worked there for many years, and I appreciate that.
and a lot of the people that I had the pleasure of working with are still there. They're still doing the job. They're still my friends, still my colleagues, and I consider myself a correctional professional. I'm proud of that profession, and even as a retiree, I try and keep up with as much as I possibly can about how things are done on the inside. So, yeah, I have a tendency to refer to we.
Right, and I wasn't trying to argue with you about that. I was just making sure, clarifying. Talking about the defendant's behavior in the Hillsborough County Jail, you agreed with me he's been in lockdown the entire time, meaning he's in a single cell by himself in isolation.
Correct.
All right. And even though he's in a single cell in isolation, are you aware of the fact that he did have a disciplinary report involving obtaining cannabis?
Obtaining cannabis?
Cannabis,
Inside
marijuana.
the jail?
Yes, sir.
Jail staff did not advise me of that.
Okay. Real quick, I'm not going to spend a lot of time with you on it. I just want to cover a few things that you talked about on death row. Death row, people who are sentenced to death and on death row, they are in a single cell. Is that correct?
Correct.
With nobody in the cell, with no cellmate, right?
No, sir.
All right. And you talked about medical call-out. You said it's safer for them to bring a doctor there some of the times for minor medical issues rather than the safety issue of having to shackle the inmate and take them to the infirmary.
Correct. And
Is that right? Do the prisons maintain infirmaries?
we do have an infirmary at most every institution. There are some work camps, work release centers that may not have an infirmary, but or a medical unit. But most every institution, major institution in the state of Florida, has a medical unit.
All right. And you talked about the privileges that they have on death row, that they can have their own TV, correct?
They can.
It's a very small little TV, isn't it?
It's not your 19-inch or
No.
your 40-inch.
It's about like that size, maybe like 6 or 7 inch screen or something.
I would, best of my recollection, I would say they're no more than a 12-inch.
No more than a 12-inch screen. All right. And they can have access to certain shows or movies, correct, that are limited.
Well, the television system inside of a prison, most all of them are antenna. So it's according to what you can actually get through an antenna. They may have 5 to 10 channels that they can watch: ABC, CBS, NBC.
Standard network stuff.
Right.
So this isn't cable TV or
Unless
or dish TV or anything like that, right?
Unless there's been a change in the last couple of years since I've left, no, we don't have the cable TV.
And they have times when they're allowed to watch the TV and time limits when it goes off.
Correct.
All right. classification you gave us, the is it H05 or H05?
And H05.
H05, they'd go into a general population housing unit. They'd have another cellmate. Is that correct?
Yes.
They would have times where they would be allowed to go out on recreation, and they would be able to commingle with numerous other inmates, correct, during that time?
That would be correct.
How many hours is that a day on recreation?
It's determined by the time of year, and it's also determined by the work schedules and the availability of staff. And right now, I mean, we're 5,000 staff members shy in the Florida Department of Corrections, so we're working short in every institution. That can affect the amount of time that they get out on the rec field.
Is that outdoors, the rec field?
The rec field is outdoors. It's according to the individual facilities as to where the rec yard is located at. Most of the new prototype, the units are set up to where you can quarter them. And so basically about an eighth of the compound is for recreation purposes. That incorporates a track and a few pavilions that you could sit around under.
Okay. So you can walk on the track or run on the track?
It's not a real track, but they kind of walk the fence line. It looks like a track when you see it because they kind of beat a path out there.
So you can go out and you can exercise?
You can.
Right. There is a canteen, which is basically, for lack of a better way of saying it, a store where they can purchase, you said, deodorant and comfort items. They can purchase snacks, candy bars, and potato chips and things like that.
Yes, if you have money in your canteen account, you can.
Right, and I was going to talk about that. If you have a friend or a girlfriend who wants to bring money and put it into your account and give you a steady flow of money in your canteen, you're going to be able to buy stuff through that store or that canteen, correct?
That would be correct.
Things that make it comfortable for you.
Correct. But by the same token, that would be the same for death row. The inmate still has an inmate canteen account, the bank account that he can purchase from. He would have to place his order, and then the order would be filled and brought to him at the appropriate time.
They go to chow hall, too, you said, when they're in the H05.
Yes, sir, they do eat in the chow hall.
With up to 80 to 100 other inmates?
That is correct.
How much time are they given for that per day?
They would go to chow 3 times a day.
For 3 meals?
For 3 meals.
And those are provided by the state, correct?
That is correct.
In addition to whatever they want to buy in the canteen?
That is correct.
And they have medical care provided to them?
Everybody in the Department of Corrections has medical care.
That's part of the proper care, part of the qualification and certification you were talking about earlier?
Absolutely.
I have nothing else.
Okay, read it.
Briefly, Mr. Land, are you aware if generally there is more money placed in death row inmate accounts versus...
Objection to relevance.
I'm going to sustain the objection.
That's all I have here.
Okay. All right, may this witness be excused? May this witness be excused, Mr. Hernandez?
Can we approach?
Sure. That specific question.
Are you aware if, on a general basis, there is more money placed in death row inmate accounts, canteen accounts, versus general population?
That would be a hard question to answer.
Well, let's not.
And let me be
speculate.
more specific. I'm sorry.
If you know, great. But if you're just going to guess, then
I don't, Your Honor, because I've seen inmates with $500,000 in their inmate account. I've seen them with none. So
why don't you rephrase your question?
If I could rephrase, are you aware of people actually donating money to death row inmates because of the fact that they're on death row?
Yes.
Thank you.
Okay. May the witness now be excused.
Yes, Your Honor.
Okay, thank you. You're free to go. Any further witnesses today, Mr. Hernandez?
We have another witness, but I don't know if we want to get started.
Okay, well, come on up, let's talk about it.
Well,
Now we're all talking the same language. Okay, so there are not going to be any further witnesses today. So as I indicated, you all will return tomorrow at 9 a.m. and there will be additional witnesses, and we are still on track to get the case to you for your consideration sometime, I would say, early afternoonish, I'm thinking. So just remember my previous instructions. When you go home tonight, don't listen to, watch, read any news accounts related to this case. Don't talk to anyone about this case, and don't do any independent investigation of your own. And tomorrow, when you come back, you do need to bring an overnight bag, just in the event. You do have to be sequestered, and I would encourage you not to bring razors, so that way you don't the situation with security. So if there's anything that might hold you up through security, just be mindful of that when you're packing your bag. Okay? All right, so I'll see you all tomorrow morning at 9 a.m.
All rise, jury's exiting.
Okay, very good. See you all tomorrow morning, and we'll start with Dr. Wu, correct?
Correct.
And then do you have any other witnesses?
the video.
The video, okay. And then state, you've got Dr. Lazaro, okay. And then you've got the one other rebuttal witness regarding the video, correct?
And Dr. Holder.
And Dr. Cole,
The
okay.
PET scanner.
All right, so we just need to be, defense may rest, mid-morning-ish, mid-late morning-ish, so state you need to be ready to roll right into whatever we're gonna call it.
They'll be here.
Okay, all right, very good, see y'all tomorrow.
All right, thank you, Ron. Oh, yeah.